Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services, what they mean for your business, your customers, and the industry. This is a weekly podcast show brought to you by the Consumer Financial Services Group at the Ballard Spahr Law Firm. And I'm your host, Alan Kaplinski, the former practice group leader for 25 years, and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'm very pleased to be moderating today's program. For those of you who want even more information, don't forget about our blog, consumerfinancemonitor.com. Yes, it goes by the same name as our podcast show. We've hosted the blog since 2011. On the very same day that the CFPB became operational. At that time, it was called CFPB Monitor, but we changed it during Trump 1.0 to Consumer Finance Monitor because we expected there would be fewer developments at the CFPB, and that turned out to be the case. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know about it. You can leave us a review on Apple Podcasts, YouTube, Spotify, or wherever you obtain your podcasts. Also, please let us know if you have any ideas for other topics that we should consider covering or speakers that we should consider as guests on our show. So today is part 2 of the podcast show dealing with this very important subject of new CFPB enforcement policies that have been implemented by Acting Director Russell Vought and the impact of the proposed reduction in force on the enforcement division. For those of you who missed part 1 of this show, I strongly recommend that you either download part 1 on our website, ballardspahr.com, or it is available wherever you get your podcast programs, be it Spotify, Apple Podcasts, YouTube. And you really need to listen to both parts of this podcast show in order to get an accurate picture of what's been going on at the CFPB since Acting Director Vought got appointed by President Trump, and what the future looks like for enforcement at the CFPB during the remainder of 2025 and perhaps for the remainder of President Trump's term. Well, let me introduce our guests today, and I'm very excited to introduce both of them because I don't think when you talk about going to the horse's mouth, we're going to hear from the horse's mouth today. And I'm going to introduce first Eric Halperin. Eric is currently a senior fellow at the Consumer Federation of America. From 2021 to 2025, which covered the entire term of Rohit Chopra, who was director, he served as the enforcement director at the CFPB. From 2010 to 2014, he served in leadership roles in the Civil Rights Division of the Justice Department, first as Special Counsel for Fair Lending, and later as Acting Deputy Assistant Attorney General, overseeing the division's fair housing, fair lending, and employment enforcement programs. From 1998 to 2004, he was a trial attorney in the Civil Rights Division, and in addition to his government service, he's held leadership roles in the nonprofit sector including as director of the Center for Responsible Lending's litigation program and its Washington office. And now, let me introduce my other guest, and that is Craig Cowie. Craig is the Blewett Endowed Faculty Chair in Consumer Law and Protection and a professor of law at the Alexander Blewett III School of Law at the University of Montana. He also is the inaugural director of the Blewett Consumer Law and Protection Program at the law school. Prior to joining the faculty in 2018, he practiced for almost 2 decades, including most recently as an Assistant Litigation Deputy in the Office of Enforcement at the CFPB and as a partner in the DC office at Jenner and Block. So, Craig, I also wish you a very warm welcome and look forward to you sharing your thoughts today. So let's turn to I was going to say 21 cases, but another case got dropped yesterday, I believe. So as I understand it, there were 38 cases when Director Chopra left the Bureau, 38 active enforcement cases, and 22 of them have been dismissed with prejudice. Eric, can you tell us, what's going on there? What types of cases are they dismissing? The ones that are left, I don't know if they indicated they do intend to litigate some of them, and maybe in other cases there are stays in effect and they haven't had to show their cards. But what's happening there?
Yeah, so as of the date of recording this podcast, there are 22 cases that have been dismissed. Just a quick overview of kind of what make up those 22 cases so far that have been dismissed. So 16 of the 22 were filed before the November election. Well over half of the dismissed cases were filed in 2023 or earlier. 2 of the dismissed cases were filed before President Biden was sworn in. So this is a diverse docket in terms of when they were filed.
So are you saying they even dismissed a couple of cases that were brought under Craniger or Mulvaney?
They dismissed one case that was brought under Director Craniger, and it was also a mortgage case. So it was not only
high priority, right?
Not only under Director Craniger, but exactly one of their priority issues. And a case that had been, litigated for years, was through summary judgment. We were getting ready, for trial. That was one of the cases that was dismissed. The second case was a case that was dismissed that was filed in 2017 under Director Cordray while President Trump was in office, but then litigated all through the Craniger years, litigated all through Director Chopra's years. And actually, this is the National Collegiate Student Loan Trust case, settled in January of 2025 for redress for harmed consumers. So this was a case that involved the trusts, among other things, collecting on student debt, their agent collecting on student debts without being able to prove they own the debt. So it was a debt collection case, very, evocative of some of the things we saw during the financial crisis. Litigated for years, a settlement secured for redress for consumers, also one of their priorities, redress for harmed consumers. And initially, the Trump administration, it was the investors in the trust opposed the settlement. Initially, the new Trump CFPB filed an opposition saying the settlement should be entered by the court, only to later, just a month later, to dismiss that case. So that's one example of the case that was dismissed. One of the cases that was dismissed was against Capital One for deceptive conduct in their savings accounts. That case just recently, there was a private companion lawsuit that just recently, there was public reporting that has settled for over $400 million. There was a case against TransUnion for deceptive conduct in their direct-to-consumer marketing of credit monitoring. That was a case that was filed under Director Chopra, but based on findings of the supervision division under Director Craniger, which found that they repeatedly violated a previous order. There were cases involving illegal fees. Once again, I think that's another one of their priority areas, fraudulent fees charged to consumers, including a a subprime credit card where consumers paid $300 membership fees and could only use the card at store run by the company that ran the card that was overpriced and had limited options. There's also the lawsuit against Zelle and three of the largest banks that were owners of Zelles for failing to prevent fraud on the Zelle network. When they knew that fraud was occurring, they didn't take reasonable actions to stop it.
Well, on that case, so Eric, did that one involve the question of whether or not the bank ought to be liable for transactions that were actually authorized by the consumer, where the consumer got scammed, no question about that, but the customer authorized the transaction. And that is, an open issue for sure.
Yeah, the specific issue in that case was whether if there's a circumstance where the bank or the network was aware that fraud was occurring and they failed to take reasonable action to prevent the fraud, under that circumstance, could they be liable, which is slightly different than them being liable for all the fraudulent transactions that occur on the network. But then in addition to, so some of the other things in the, you asked about, sort of what's left. So we have this broad swath of cases that have been dismissed that include mortgage cases, that include cases involving fraudulent fees, that include cases that were targeted on getting redress to consumers that faced actual harm. Broad swath of those cases that have been dismissed. By my count, there's 15 cases left. There's a couple cases in there involving the Military Lending Act. There's about half a dozen cases involving illegal advance fees. There's a case against Experian for failure to have legally adequate policies around dispute resolution that are remaining. But there's not really a clear picture when you look at the dismissed cases and what's left on the docket and their memo about what their priorities are. It doesn't give you a clear picture of actually what, if anything, they're going to be doing going forward in enforcement.
So, and I agree with that. And I think also it's, we have this existing world of cases, universe of cases, but in 2 weeks, is that going to be the same? We don't know. So it's possible a lot of stuff does happen during, when you're in court, there aren't court deadlines every day. You frequently, there are long stretches of litigation where the parties are just engaging with each other and the court's not involved. So we don't know even if whether or not this is even intentional what's left, or it's just simply the cases that they haven't gotten around to dismissing, or that I think, and this argument was made vis-a-vis the service member cases, which they initially said one of the early things they did is they came out and said, well, we are going to prosecute this service member case. But, the question becomes well, did you say that because it's a priority, or did you say that because the public relations blowback of dismissing a case that is designed to protect service members, was not a thing they wanted to take while they're in the midst of riffing the department? So I think that's one thing. I think also it's important to note, because I've seen some reporting saying, well, Chopra filed a bunch of cases at the end, so they're just rolling them back, and that's normal. This is not normal, right? This never happened before. And I've done a pretty close study of the Office of Enforcement over the years, both academically and when I was there, but I'm really only aware of one case prior to this swath of dismissals where a director dismissed a case that had been filed by one of their predecessors. As Eric noted, Mulvaney and Craninger kept enforcing all but one. Mulvaney dismissed the one case, which was fairly early in the litigation process. But otherwise, they enforced all the cases brought by Cordray that were still in. Weggio and Chopra, when they were acting director and director, they continued prosecuting the cases that Craninger had brought, even though maybe those cases didn't match up with their priorities. They continued doing it. So this idea that all of a sudden, when you're doing your prosecutor's discretion, you're going to dismiss more than half the existing cases, that's completely unprecedented. I've never seen anything like it in any agency. And I also would just say that it's also just as a factual matter wrong. So if you look at the last 90 days from leading up to the inauguration of a president where there's a change in power, Chopra filed the fewest cases in that 90-day period than any of his predecessors. Croninger filed the most. Now, the numbers are really, like, I think Chopra filed about 16 in the 90 days prior. Croninger filed 20. You know, that's a similar enough amount. You know, Cordray, back when he was director leading up to the inauguration, as I said, there was some thought that he'd be fired on day one, although he wasn't. He brought about 17 or 18 cases. So this idea that there are a bunch of cases brought, that's just factually not true. What happened in this context is what has happened in every presidential transition since the Bureau existed. It's just that now they're dismissing all the cases.
But Craig, yeah, no, you're right factually, but there were a lot. It just seemed like there was an extraordinary amount of activity that was occurring toward the end of Chopra's term. Now, the amount of new litigation was normal, but it seemed every day there was either a new proposed reg or a new guidance, or it just seemed like we were being bumped. I mean, because we cover it in our blog, it was nonstop. I mean, it was just so much activity. And I thought that that turns out not to be a wise move because of the Congressional Review Act. And there have been 2 final regs that have been overturned under the Congressional Review Act. It becomes very hard for the CFPB in the future when there's another change in administration to adopt a regulation substantially similar to the one that was overturned by the CRA. So anyway, what is that a fair point, Eric?
Well, I want to pull it back to enforcement and pick up on a point that Craig made that's responsive to one of your questions, which I didn't get to, which was also what is this? What do we know about the docket that's continuing? And is it really just because these haven't been dismissed? Does that mean they're really committed to bringing those cases forward? And I'll note, so I mentioned the case with NCSLT where they had initially, opposed the objections to the settlement. So that indicated they wanted that case to be brought to finality. Also in Comerica, the Trump administration originally authorized the filing of amended complaint, only to dismiss their own amended complaint a few weeks later. So I think there's just a great deal of uncertainty, even around the current docket, about whether that's going to continue. Because again, when we look at their actions, we've seen them publicly commit it through filings to seeing a case forward, only to see that case pulled back. So I think there's just a great deal of uncertainty. And I just would encourage us, we just got to keep looking at what they do, because I think that will tell us more about what they're going to do in the future rather than what they say.
Yeah. I want a follow-up question for you, Eric or Craig. They talked about they're no longer going to bring cases based on novel legal theories, or what we would colloquially refer to as pushing the envelope. And the only case that I recall seeing that might arguably fit in that category were the lease to own cases. It was questionable whether or not they constituted credit, and there were good arguments that could be made by the companies. But was there anything else other than that would fall into that category? I know you may not want to concede it's a novel legal theory, but something that's in a gray area.
Yeah, well, I guess what I would say is, as you pointed out in the memo that appeared to focus on supervision, they didn't mention enforcement. We don't know we're not trying to overread the memo because we don't know how serious it really is as an expression of future priorities. But I would say that, certainly every lawsuit we filed went through a rigorous internal process, not just the factual investigation, but internal processes, a lot of back and forth with the legal division, other aspects of the Bureau to make sure that there's more than sound legal basis for filing the lawsuit. And I think one of the reasons we have UDAP authority in the world, not just at the Bureau, but at the other federal enforcement agencies that have it in the states is that there's often unique facts, lending practices change, facts on the ground change, but unfairness, deception, and abusiveness, the legal concepts behind that need to be able to apply to unique situations. Otherwise, we can see broad-based evasion of the consumer protection laws by new or quote-unquote innovative lending models. Sometimes those innovative lending models are set up in particular to avoid legal compliance and regulatory regimes. And if they do that in a way that is unfair, deceptive, or abusive, then that's what that authority is there to issue. So I would say that sometimes we have new facts and new factual situations, new business models, and what we have is the legal principles that underline UDAP, and we just apply those in a fair and consistent way based on the previous law.
So, just to echo Eric's point, I think what's telling is that UDAP authority, so unfair, deceptive, and abusive, if at least with respect to the CFPB practices authority, the legislatures and Congress, when they've given that authority, it's precisely for the reason Eric said. Like they are explicit that this authority is given in order to prevent the arbitrage and the sort of gamesmanship that was happening. If you passed more specific laws, you even see these debates where somebody will say, well, we should just lay out the unlawful conduct, and the counter will be, well, yeah, but they'll just go around that. And so we need to have a list. And so you do get hybrid statutes like the Fair Debt Collection Practices Act, where they'll list a series of things that Congress has determined and said, you know what, these are illegal. We're not going to let you do these practices. But you'll note that even there's also a kick in, like one of the things you can't do is be deceptive, right? We're not going to define that because there's a long settled body of case law. I think what Eric called the principles of UDAP are very well understood and have been for a very long time, with the exception of abusive, just because it's newer. But so we understand what that means. And then there's always the fight about when we apply it to a new factual situation, is that novel? I would argue no. Other people might say yes. But I think in the end of the day, what will be interesting will they be bringing these cases? Because they said they've got these priorities, but I think, Eric was talking about the NCSLT case as debt collection. Well, debt collection was one of their priorities too. And yet they dismissed the case where they had a settlement. And I think just another unprecedented thing that I think it's worth noting is this, at least twice, they have now gone and tried to undo, and I don't know exactly this, and Eric, correct me on the NCSLT if that should be included in this category, but in Townstone, the case, there was stipulated judgment in court done, and they moved to reopen it. In Wise, they had a settlement for a set penalty amount, and then they went ahead and reopened it and lowered the penalty amount. I've never seen a new Office of Enforcement and I haven't looked at the other agencies as well, but I'm not aware of any situations where they've gone in and retroactively changed settled cases that were, would arguably subject to all the preclusion principles we all learned about in law school, right? And went ahead and reopened them to change the terms. I've just never seen that anywhere, and I think that's worth noting.
Yeah, I think that's an excellent point, Craig. Yeah, I think what we've seen, obviously what they're doing on dismissed cases, completely unprecedented. Previously, one case dismissed without prejudice, now 22 cases dismissed with prejudice, meaning the Bureau will never be able to bring a claim in the future for the actions involved in those lawsuits. And then what's happening with the settlements is really one step further. And I think really an excellent point by Craig, in many cases, contrary to their expressed priorities. So you mentioned the Wise settlement and Townstone, which is currently still pending in court, their efforts to try to unwind that one. We also saw an early termination of the order against Toyota Motor Credit, including an explicit termination of the redress provisions for harmed consumers. And also, I do include the NCSLT case because that was a case where you had a settled case. There was $2 million going to consumers. And now that money, because they've dismissed the case, is not going to happen. And it was a case that was settled. And we have instances where, entities represented by sophisticated counsel agreed to settle matters in some of these cases, well before the election or years before the election, and now going back and undoing those cases is unprecedented. It's a threat to the stability of enforcement orders going forward, and I think has long-term consequences for the Bureau or other federal agencies' ability to enforce the law, and is among the many very disturbing things happening from the new leadership. This moving into undoing settled cases, I just think is an incredibly dangerous precedent.
It's probably going to, the fact that they have done that on 3 or 4 occasions, if I were representing a company that had signed a consent order anytime during the Chopra era, I'd be seeking to get it undone too. I mean, it's if you're representing somebody who paid millions of dollars, and then you see that the CFPB undid some other settlement, the first call I'd make would be to my lawyer. Well, why can't I get that too? Anyway, let's talk about the future here. Assuming, well, first of all, can either of you define for me what is statutorily required by the CFPB? That seems to be the litmus test, right? That's the litmus test that the courts, I think, are going to look to. That's the thing that the consumer advocates have relied upon, that they, this RIF was going to result in them not performing statutory duties, and can't do that. So what does it mean in the enforcement context? Does it mean you have to bring a certain number of cases? You have to do a certain number of investigations?
Well, I'm happy to start and then have the professor chime in. Right. Well, so enforcement is a statutory mandated function of the Bureau. That's clear from the CFPA. You need to have the ability to enforce the law. Also, specifically, the CFPB is responsible and is statutorily mandated for enforcing those 18 enumerated statutes, plus the UDAP provisions of the CFPA, right? So those are statutorily mandated activities. There's also a number of other specific activities that are mandated that go within enforcement. So the idea of, can you have a Bureau without an enforcement function? Absolutely not. Congress has made it clear that the enforcement function is statutorily mandated, and that is a requirement. Also, within the statute, one of the things that's mandated is that one of the purposes of the enforcement is to ensure consistency between bank and non-bank markets. As we know, those of us who were doing this work before the financial crisis, one of the significant issues was that we had a lower enforcement, lower regulation of non-bank actors. It created a race to the bottom for illegal and risky conduct. And we had widespread harm in terms of foreclosures and problems in our financial markets. It specifically responded to that. So that means you have to have an enforcement function. You have to be able to enforce this function. Your enforcement function has to be significant enough to ensure a consistent application of law across these large markets. And so I'll turn it over to Craig to add anything on that.
Yeah, I think it's a really tough and sort of abstract question at a certain level. But I think, to echo Eric again, right, you must have an enforcement office, and it must be functional. But I think the place to look is just the statement of purpose, which says that the Bureau shall enforce the law, not only consistently, but also to ensure that all consumers have access to markets, and to ensure that the markets are fair, transparent, and competitive. And so it's not just that it's got an obligation to enforce some cases. It actually has the affirmative obligation to a statutory mandate to ensure that the markets work in a way that protect consumers and that all consumers can participate in the market. And also that doesn't put good actors, so companies that want to abide by the law, right? One thing about this deregulatory chaos is that it gives a competitive disadvantage to companies that have invested in programs to comply with the law. And it gives an unfair competitive advantage to fly-by-night companies that are going to cut corners and don't want to comply with the law. So in other words, it creates exactly the wrong incentives for structuring a market and exactly opposite what Congress directed. And I think it's important. I mean, everybody has a short memory here, but the Office of Thrift Supervision is by Congress, I will note, disbanded in the Dodd-Frank Act. And for a host of reasons, but one of the reasons that gets echoed repeatedly is its failure to enforce in its marketplace, to ensure that the marketplace worked correctly. Several inspectors general noted that OTS, critiqued OTS for failing to bring enforcement actions in a timely manner that might have mitigated what became the 2008 housing crisis. So enforcement, part of the reason enforcement is so important is that creation of that market doesn't happen absent government action, right? I mean, we want the marketplace to work a certain way. We want it to be fair, transparent, and competitive. And that means the government has to take actions to punish companies that violate the law, that harm consumers, that harm their competitors. And so the enforcement objective, I would argue, that's required by Dodd-Frank is actually broader than just this bringing cases. It's the regulation and the creation of a market that acts the way Congress intended for the market to act. And at that higher level, that's why to circle all the way back to what Eric said at the very beginning, which was when he said, look, even if we had priorities, we watched the entire marketplace. That's why that's an important function, is because if we just say we're going to look here and we're not going to look at that stuff, the odds that those markets are fair, transparent, and competitive drops to zero, right? That's what's going to happen. We're going to see more unlawful conduct. We're going to see good businesses be hurt. We're going to see consumers be hurt. And so effective enforcement in the way that Congress intended is the kind of enforcement that is a bulwark against another financial crisis, right? Trying to make sure that, and the idea there is that making the market work properly. Is that what we want?
Right. Well, now I'm going to ask you an unfair question, but, I didn't promise you this would be easy. Let's say either of you were still, at the CFPB, and Eric, you were still the chief of enforcement, and they did a RIF, and they told you you've got 50 employees right now. What would you do? I mean, I'm just curious. Would you throw up your hands and say, it's ridiculous? I can't run this agency with 50 employees because I wouldn't be able to perform what I think is required under the statute. What do you think? Eric first and then Craig?
Well, remember, you're like 50 employees is like almost like a theoretical number, right? Because the second large scale RIF was 50 employees. It wasn't a well-designed 50-person enforcement office, and it was a number that included 11 employees on probationary status, which would be vulnerable for being dismissed. It included about 28 employees that were located outside of Washington, D.C. that could potentially be forced to move to Washington and lose their job. So even this 50 number, I'm not sure that they threw out as a real number. But I think what it comes down to is a question of, let's just say the number 50, is that a number to adequately perform the statutory functions of the job? And I think it's a clear answer of no. There's no way you can perform the statutory functions of the enforcement office on that. And I think it's important as we sit here now, I'm not there anymore. I left the Bureau when I was told that we couldn't do any work. We were told to fully stand down and we couldn't even, make our appearances in court. But I think as we look at this now and we look at the situation now, the question is like, what does it take for the Bureau to accomplish its statutory duties? Every director that is an acting director that has been in place at the Bureau has had an enforcement office that was magnitudes larger than 50. Even Director Craniger did a full review of Bureau resources, made some determinations about what supervision and enforcement needed. And what she decided was magnitude larger than 50. So I don't think there's any question that this 50 number is not adequate to perform the statutory functions of the job.
Right. Well, and then one other thing I want to just loop into the discussion, and that is, I assume that a major source of the litigation that was brought by the CFPB when you were there emanated from supervision, right? I mean, a lot of things percolate up from supervision, they're referred to enforcement. So with supervision being reduced to 50 employees, aren't going to be very many exams that they're going to be able to conduct. And there aren't going to be the source of cases, at least part of the source of cases is being cut off.
Yeah, that's a great point. And I want to turn this over to Craig to get in on his impressions from when he was at the Bureau and what he's looked at. But during our time, the number of cases on our docket that resulted from referral from supervision, it was about a quarter of the docket. But also in certain markets, like the mortgage market, their priority market, supervision is incredibly important. And the exams they're doing both on origination and servicing are very important, not just as a source for enforcement, but for ensuring compliance with the law. And so a 50-person supervision office without any of the ability to do risk-based supervision or any of the expertise that they laid off and that they attempted to lay off in the Office of Supervision Policy is no longer going to be a source of significant number of cases for enforcement. So I think all this comes down to putting the institution in a place where it's impossible for them to enforce the law and impossible for them to do all the things that Craig so excellently put is essential to the enforcement function as required by Congress.
Yeah, I think the only thing, a couple of things I would add to that is one, that part of the genius of the way the Office of Enforcement operated, at least when I was there, was that not only it wasn't just, so cases do come over from supervision, but enforcement had its own strategy team that was monitoring the marketplace, as Eric mentioned earlier. And so enforcement itself was looking for cases and trying to see what concerns were bubbling up through all the various markets that the CFPB had to cover. And that's sort of the SEC's model was very similar to that. They tended to bring enforcement actions based on what the enforcement attorneys would find, in addition to some other things. The other thing I wanted to note was, so even at its lowest the current proposal, that's on the table as being quote unquote sufficient is 200 employees. And the CFPB has historically been somewhat vague, shall I say, in its staffing numbers for various offices. It's very hard as an outsider, as I am now, to get data on this. But if you look at the end of fiscal year reporting, the lowest number in recent memory was, after Mulvaney instituted a hiring freeze. So he wasn't firing people, but he froze everything, which I would argue was inappropriate as well. I mean, he froze it for too long, I think. And so there was attrition. At the ebb, the Bureau had over 1,400 employees under its reporting. And Craniger brought that level up to over 1,500 before she left office. So she was actually hiring during that period, bringing people back on to what she must have perceived herself. I mean, I can't speak for her, but presumably she felt like there was a need for those employees, and that's why she authorized their hiring. The other thing is that Congress specifically specified, let me restate that. So take that off. When Congress passed Dodd-Frank, they set the agency's budget as a significant percentage of the Fed's budget, understanding fully how much money that was, because that was their indication, was that the agency that they wanted to create to prevent another meltdown was going to require resources of that level or up to that level. And although the agency, I don't think, ever went over that number. It had the authority to request more if it wanted. I don't believe it ever did, but that number is very, very high. The idea that a 200-person office would satisfy Congress's intent when they've given the CFPB by statute 12% of the Fed's operating budget is insane, right? There's just no evidence to support that conclusion, right? Congress understood and wanted a robust agency.
It's interesting to know, Craig, that in the budget reconciliation, the big, beautiful bill that is probably going to, it's passed the House, probably some version of it will get through the Senate, includes a provision in there reducing the funding under Dodd-Frank, but reducing the cap, I should say, from 12% down to a cap that's about 70% lower, I think. But yet, it's not like they eliminated the funding. Congress didn't eliminate it, even though Vought so far, I think, he didn't take any funds during the upcoming fiscal quarter. I think he may have said, I'm not going to take any funds for the rest of the year. But yet Congress, if this budget reconciliation passes, says, I guess the one message you can read is we still want the Bureau to exist at a reduced level of funding, but not the level of funding that, is being contemplated by Vought.
Yeah, although I think, Alan, that's an excellent point. And it raises, I think, what is something we haven't actually talked about, which is critical, is that that's Congress's call. It's not the administration. It's not the executive's call, right? Congress created the Bureau. Congress created the structure. If Congress wants to change that structure, I would disagree with that wholeheartedly as both an academic and just a citizen. But I recognize that Congress can do that, just like they did with the Office of Thrift Supervision. But when they did that, they did so in a very controlled and thoughtful manner when they disassembled the OTS. They created provisions to move those employees to other places or to buy them out. They transferred the authorities to other places. None of that is happening here because the executive is just shutting down the Bureau, which is very different. So and I agree that even at 70%, that's much higher than 200, even with a 70% reduction. I also know that hasn't passed yet. So we'll see. But if Congress wanted to restructure the Bureau, there is a proper constitutional way for them to do it, which is they can just pass a law that is signed by the president and then we'll do it. But that's not what's happening here. What's happening here is a rush to shut things down before they can be stopped, right? And I think what Eric said earlier about the fact that there was this sort of race to the first RIF and a race to the courthouse to prevent the RIF before it happened. And we saw this also in the, some of the transporting prisoners to Venezuela, to El Salvador, the Venezuelans to El Salvador, was that there's documents out that these moves were afoot. They were trying to actually get people were on buses headed to the airport when the court acted. So we're seeing that here too in the RIF process. It is undoubtedly true that Congress could change the structure of the Bureau. And in fact, every Congress since the Bureau was created, for the most part, has attempted to pass some bills changing the structure of the Bureau. So far, none of them have been successful. Right? They've never gone through Congress and become law. But they could do that. But what can't happen is what happened here, was where the executive just says, Congress has told us to do this thing, but what we're going to do is shrink it all the way down to just 200 employees. Like that's not faithfully executing the law as Congress has laid it out. And I think Eric wanted to jump in on something here too.
I think it's an excellent point. And basically what we have here is actions that are being taken that are absolutely inconsistent with the congressional mandate. And importantly, rewind the clock to a time when law-abiding companies were disadvantaged and companies that are willing to break the law and underinvest in compliance had a market advantage. And the consequences to that is not only going to be potential huge harm to consumers, but it's destabilizing to our financial markets. It's bad for the companies that have rigorously invested in their compliance systems. And that's a key part of their business models. And those are exactly the things that Congress was responding to when they set up the CFPB. And I don't think any of us want to be back in that world again. And it's just an incredibly dangerous time. But we have, I think one of the great points that Craig made is we're not just taking down the CFPB, it's being done in a chaotic way that is just going to increase all those risks exponentially.
Right. Well, I can't resist adding at the end something I thought should have been done by Trump 2.0 instead of going down the road that they've gone down. I am as you've seen probably from the blogs that I've done and the podcasts I've done with Hal Scott, Professor Emeritus at Harvard. I believe that the structure that was set up by Congress and Dodd-Frank to fund the CFPB through a percentage of the budget out of earnings of the combined earnings of the Federal Reserve banks, that beginning in September 2022, that it was unlawful to accept any further funding. And I know it's an open issue. We're not going to debate because I know we won't get anywhere. But I really thought that's what should have been done. They should have teed up that issue. It got raised in a whole bunch of your enforcement cases, Eric, and it never really got resolved. The main issue of what constitutes earnings. I think earnings means profits, not revenues.
Well, I'll just say on that one, I was very confident. We had 7-2 on the first funding challenge written by Justice Thomas. I think we were going to do better on this one. We even had the Texas AG on our side in his 1042 action, who he also agreed that was not an argument that would undermine his actions. So.
The hope was not that would obliterate, at least my hope. I don't know what Hal Scott was thinking of, but I hope that Congress would then deal with the funding issue. And I think they could in the big, beautiful bill. I think that I'm not an expert on budget reconciliation, but if they wanted to, they could put in there a provision subjecting the CFPB to congressional appropriations rather than just reducing the cap. And that's what I was hoping would happen.
They might run into problems with the limits on reconciliation are pretty strict to avoid the filibuster, which is, I think, what they're trying to do. So I'm not sure they could do that. But I think that's an excellent point. I also agree with Eric that I think that I don't think that theory had much merit and was not likely to win. But I think your point, though, Alan, is that would have been a measured approach to changing the way. And I think everything that we're seeing is that this is purposefully not a measured approach. The tech world, move fast and break things motto is, I would argue, not the best motto for any business, really. I mean, maybe disruptive business, but I can tell you one thing it's not good for: regulating markets. Like, move fast and break things. I've watched my personal retirement account drop as we go. Like that, the effects at the CFPB and the other financial regulators, they have a profound ripple effect across the market, as Eric noted, that I think is, that's why Congress, Dodd-Frank took a very long time to come out, and it's, thousands of pages long and does a whole bunch of things. But there was lots of back and forth and debate amongst the houses in Congress, amongst committees in Congress, to develop that plan so that the result would not be a chaotic transfer as we moved authorities from seven. We destroyed one agency, the OTS, and took authorities from seven others and put them into a newly created agency, the CFPB. And all of that moved, I think, actually pretty smoothly, because of the way it was done. And so I think part of what we're seeing here is that this is evidence that the point is not to do that. It's not to take measured actions, that the actual point is to move fast and break things. And in this case, the thing being broken is the CFPB. So there's all sorts of things they could have done to lawfully alter its structure, including changing its litigation posture, as you noted, vis-a-vis some of these issues. And then those would have been brought up and litigated over the course, percolated in a couple of different cases, and we'd get a result. But that's not what they've done.
My final question, is there anything else that you want to convey to our listening audience that we haven't already covered?
I think the one, we've covered well, I think the risks that are created by these actions, and I think the skepticism that we should have of any written priorities and that need to look closely at their actions. And it certainly is my hope that the Bureau can be preserved and that, the great work that's been done in the litigation challenging the dismantling will be successful. But I think there also is, it's good for your audience to know, I think there's also going to be other actors out there. We've seen the state AGs start to pick up at least one of the CFPB enforcement actions. They're involved in some. I'm sure there'll be private attorneys who are interested in some of those actions. And just generally, we're still going to see, hopefully, significant consumer protection enforcement actions from the states and the private bar. And that is also going to be a reason people, hopefully would stick to their compliance plans because I think it's good business and it's good for consumers. But I also think there's still going to be that deterrence out there no matter what. Hopefully we'll see the Bureau also return to the field full force. But I do think there is hopefully we're going to see some other actors step into it. And I know you've covered that in the past on your podcast, but that's an important part of the story that we haven't discussed today.
Yeah, and I would just say we've had as our guests the General Counsel, the California. I always get the name of that agency wrong, but it's the major enforcement consumer finance agency in California. We've had their General Counsel on. I've had the New Jersey Attorney General, a Democratic AG on. And I've had Ira Reingold, who is the president of the National Association of Consumer Advocates. And he assured me, they all assured me, that everybody was going to be looking at all the dismissed cases. And, sometimes it may fit into the category, you better be careful what you wish for, because it might have been better continuing to litigate with the CFPB as currently composed than a whole bunch of Democratic attorneys general. Craig?
Yeah. So I had two. One, I'm going to disagree slightly that I do think the AGs will pick up some of the slack of the private attorneys as well. But I just want to note, the CFPB's enforcement office was larger by far than any other, even California, New York. It was the largest office of enforcement in the consumer space. And it was fully staffed with cases, investigations, and active enforcement actions that I think were all well taken. Even with AGs stepping up, they can't fill that gap entirely. And what that means is we're going to get inconsistent enforcement, right? So the attorneys general and the private attorneys are going to pick up some cases, but whether or not as a business, you get hit with an enforcement action, you have a little less predictability about what's going to happen in the market because you don't have the primary regulator out there acting still. The other thing I wanted to note, just because it's in their so-called priorities memo, was this idea that they're going to focus on harm to consumers. But I just want to note that one of the things we haven't talked about at all is the civil penalty fund, of which I'm a huge proponent, in part because many actors who violate the law are essentially judgment proof. And they, even if they're caught and prosecuted, they don't have the money to give back the money they stole from the consumers. Like, there's just no money there. And that's the great innovation of the Dodd-Frank Act and the CFPB, was this creation of the fund. And one of the declarations in the case was from the person who manages the fund, who was basically said she wasn't consulted at all. RIF, she's in the office of, in the operations division in finance and procurement, which had about a little bit over 50 employees and is going to be reduced to 5. They also relied heavily on outside contracts with companies. And this is an extremely economically efficient way to give money back. Operation overhead at the fund over its life is more or less about 1%. 97% of the money that's come out of the fund, which is, hundreds of millions of dollars, and there's billions of dollars in progress. 97% of the money is money that went straight into consumers' pockets. And so when I see an attack on penalties, which are necessary, which the memo has, that misunderstands the nature of deterrence and why we issue penalties. We don't issue penalties to pad the fund. The Bureau issues penalties because to deter both that wrongdoer and other companies from also violating the law, especially when consumer harm is sometimes hard to define. But what we use the fund for is Congress said, well, we're going to take this and we're going to use this to give back money to consumers who would otherwise not get their money back. And so both in WISE, when they go in and they lower the penalty from over $2 million, they reopen that case and then lower it to $45,000 with no explanation other than, that's, we followed the statute. But there was no explanation that I've seen publicly for why that penalty was dropped from $2 million down to $45,000. But if they proceed with not bringing enforcement cases or not funding the people who handle the civil penalty fund, so eliminating those FTEs, then this money is either not going to come in, we're not going to be able to pay consumers back, or money that's already in the fund isn't going to go out. That's a tremendous amount of work the Bureau does to distribute that fund. And at the time of the crossover, I think there was about $2 billion was scheduled to be paid to consumers at the time of the transition that hasn't been paid yet, right? And so I have just a question, what's happening to that money? That money should be going back to consumers, but if you're going to fire everybody in the operations department, there's nobody then to process it. There's nobody to determine what the harm is, to go through that whole process. And so this is another way in which that's not the Office of Enforcement, but that's a direct part of the enforcement effort, at the Bureau is to make consumers whole as much as they can as part of that regulation of the marketplace. And so even though that doesn't happen in enforcement, it's directly connected to the idea of enforcement. And I think that's also something that we're going to have to watch very carefully to see whether they stop putting money into, stop penalizing people, which lowers deterrence, but also drains the fund, and whether or not they actually give consumers their money back.
Absolutely. And you have a pattern with the fund and the reopening of settlements of the current CFPB leadership taking money out of consumers' pockets, harmed consumers' pockets, consumers who are harmed by law violations, and either returning that money to companies, or we don't, as you pointed out, Craig, we don't know what's going to be happening to the fund.
Yeah. Well, we got to wrap this up for today. I could go on for the rest of the day. There's a lot to talk about. But we'll now have to just wait and see what the courts are going to do and what Vought is going to do, or whoever, and the actual director who gets confirmed. I'm not sure there ever will be one. But maybe toward the end of this year, it might make sense to get together and look back at what has actually happened. But my thanks to both of you for taking the time, the effort, and appearing on our program today. Thank you, Eric, and thank you, Greg.
Thank you, Alan, for having us and for covering what obviously we, I think, both feel is a very important topic.
Thank you. Enjoyed the conversation.
Well, this brings us to the end of our 2-part show dealing with the subject of CFPB enforcement under Acting Director Russell Vought. What our special guest today think of the changes in policy that have been made, and what's going to be the result of a potential reduction in force of the enforcement division to only 25 people. And to make sure that you don't miss any of our future episodes, please subscribe to our show on your favorite podcast platform, Apple Podcasts, YouTube, Spotify, or wherever you get your podcasts. And don't forget to check out our blog, consumerfinancemonitor.com, for daily insights on the consumer finance industry. And if you have any questions or suggestions for our show, please email them to us at podcast, that's singular, at ballardspire.com. Stay tuned each Thursday for a new episode of our show. Thank you very much for listening, and have a good day.